This is Bloomberg Law with June Grasso from Bloomberg Radio.
The smiling face of the 6-year-old boy who disappeared on his way to school stared back from countless milk cartons in the 1980s. The disappearance of Etan Patz in New York City in 1979 was one of the nation's most notorious missing child cases. There was a decades-long haunting search for answers to his disappearance that put a national focus on missing children, made anxious parents more protective of their children, and changed the way law enforcement handled missing children cases. And then, more than 30 years after his disappearance, police arrested Pedro Hernandez, who worked at a convenience store in Etan's neighborhood. Hernandez confessed, and after one jury deadlocked, a second jury convicted Hernandez of murder and kidnapping.
I needed to know what happened to my son, and this great prosecution team finally proved it.
And now, 46 years after Etan Patz's disappearance, a New York federal appeals court has resurrected the case. The Second Circuit has reversed Hernandez's conviction and ordered that he be given a new trial or released, saying the trial judge gave clearly wrong instructions to the jury. The Manhattan District Attorney, Alvin Bragg, will make the decision about whether to retry Hernandez or let him go free. My guest is Paul Callan, a former New York City prosecutor and criminal defense attorney. He's now of counsel at Edelman Edelman. Paul, Etan Patz's disappearance has had reverberations in so many areas.
The Etan Patz case has influenced child rearing in America for almost a quarter of a century. Mothers don't let their kids go to school if they're in the first grade unless they're accompanied. Helicopter parenting, I think, came along in a large degree because of the fear that something like what happened to Etan Patz would happen to a child. So it's had a big influence, this case, on child rearing in the United States.
He was one of the first missing children to be on milk cartons.
Yes, he was. And I think a whole generation of kids probably grew up seeing him on the side of milk carts as they sat having their Cheerios in the morning, wondering where Etan Patz was and would he ever be found. So the whole country was mesmerized by this case, and I think it's kind of shocking that it got reversed when they finally say they got the guy who did it. And so it's a fascinating case and an interesting case.
So his body was never found. As I understand it, there's no physical evidence that links Hernandez to the crime. Was it all based on a confession?
Yes, there was no physical evidence whatsoever, and there literally were thousands of detective hours and FBI hours devoted to searching for his body. They even had cadaver-sniffing dogs that went into basements in the area where he disappeared, but they were never able to come up with a piece of physical evidence. This is a case based entirely on a confession.
And the appeals court reversal is all about the confession. So tell us about that.
Yes, and remember, this is the second trial that he was convicted at. At the first trial, the jury also, in that case, had a problem with the confession. And there was a single holdout, and it resulted in a hung jury. And then the Manhattan DA decided to retry the case. And so now we're in the second trial. And during that second trial, the jury's having major problems with the confession. And this is the reason they're having a big problem with the confession. When he confesses, Pedro Hernandez confesses, he's in New Jersey. He's in Camden, New Jersey. And New York detectives go to New Jersey, and they put him in an 8-by-10-foot room with no windows in it. And they begin to ask him questions about the disappearance of Etan Patz. They did this because they got a tip from one of his family members that maybe he was involved in the disappearance of Patz in 1979. And he's questioned intensively by New York City detectives without Miranda warnings for a period of approximately 6 hours. And during that time period, they even bring him drugs because he said he had left his medications at home, and they send the detective to his house to pick up a bottle of pills along with fentanyl patches, and a fentanyl patch is put on him as well as he's allowed to take the pills. And the confession continues. There's a camera mounted in the ceiling of the 8-by-10-foot windowless room, And there's apparently a Manhattan assistant district attorney watching the questioning from a remote location. And at the very end of that time period, he confesses to having killed Etan Patz, putting his body in a garbage bag and then throwing it in the trash. And he says that he encountered Patz outside of a bodega that he, Hernandez, worked at, offered him a soda and brought him inside and murdered him. The confession then is repeated later on when he's brought back to Manhattan to the assistant district attorney that, in fact, was watching remotely when the first confession was given. And this time he's given his Miranda warnings. At the time of the initial confession, he's never given Miranda warnings by the police. They say he was not in custody, despite the fact that he's in an 8x10 windowless room for 6 hours being questioned by a team of detectives. So problems with those confessions are the central reason that the United States federal court has reversed the conviction.
During deliberations, the jurors sent out a note to the judge asking whether they should disregard the later recorded confessions if they found that his first confession off camera wasn't voluntary. And the Second Circuit said the judge gave them the wrong answer.
Yes, that's exactly correct. What the note said was, if we find that the initial confession that was given in New Jersey was not voluntary, can we still consider the subsequent confessions that were made when he was brought back to New York? And essentially the court said, yes, you can consider the subsequent confessions. So they went on then to look at the subsequent confessions, which occurred after Miranda warnings, and he incriminated himself in those confessions as well. So the conviction was based on those confessions.
And why did the Second Circuit conclude that the judge's answer or decision was wrong?
Well, there's a case called Missouri versus Siebert that is the central case that the court refers to. And back when the Miranda decision came down, the cops had come up with a workaround. And here's the workaround. Let's take the person into custody and get a confession out of the person, and then give him Miranda warnings and ask him to just repeat what he had said in the initial confession. And this became a widespread technique that was used across the country. Eventually, the federal courts had to step in, including the Supreme Court, to say, no, this is completely improper. You can't do a confession without Miranda warnings and then subsequently give the warnings and ask the person to repeat what you just said. And that's this Missouri versus Siebert case. And the circuit court here, Second Circuit, said no. They ignored that case. They didn't rule properly on that case. There wasn't a significant, what they call, attenuation between the initial confession, which had no Miranda warnings, and the subsequent confessions when the Miranda warnings were given. The Siebert case basically says that there has to be an attenuation, a distance between the two interrogations if you're going to just administer the Miranda warnings belatedly. So that wasn't done in this case, and for that reason, the conviction was overturned.
I'm just curious about in real life. So we hear the Miranda warnings in TV shows and movies over and over again. Most people can recite them. Does it really make a difference to, someone in custody if they hear those Miranda warnings?
To tell you the truth, June, I don't think so. And, when I started out my career as an assistant district attorney in New York City, we used to ride homicide cases, meaning we would go out to the scene of the crime and administer Miranda warnings to the suspect. We had a stenographer with us, and it would all be taken down. But frankly, we didn't know what went on, what really went on before we got there. Now, the police would say we administered warnings to him before the DA arrived and took the formal statement. But who knows what went on? I mean, it's only the police in the room with the suspect, and the atmosphere is very different before the lawyer arrives on the scene. But my experience was that the Miranda warnings have become so pro forma, and all of the potential defendants in criminal cases know the Miranda warnings, so they're not getting any new information. And if they're intent on confessing, they confess without asking for a lawyer. It's really only sort of educated professionals and mobsters who ask for lawyers, not day-to-day violent criminals.
So now the Second Circuit said that either free Hernandez or put him on trial for a third time within a, quote, reasonable period. Talk about the obstacles of trying him again
Well, they're going to be up against exactly the same obstacles as the first time around, because when I looked into the record of this case, remember, this appellate decision that was issued by the federal court is 51 pages in length. They recount in detail all of the strange things that happened during this interrogation. He was found by several experts to be a schizophrenic suffering from bipolar disease who was also using fentanyl and other drugs. This is all taking place when he's being interrogated, by the way, that he was suffering from these conditions and using the drugs which were supplied by the police. So in the absence of new evidence that would physically link him to the crime, I think you're very much in a situation where you'll be looking at another hung jury or maybe even an acquittal on a retrial. Now, the DA in the last case was Cyrus Vance, who decided to proceed with this case, and you have a new DA now, Alvin Bragg. And I'm not so sure that Alvin Bragg's going to want to get involved in the Etan Patz case just because of the problems with the evidence. And something else, there were at least two other suspects who were child abusers who were thought to be in the vicinity of the crime and who were intensively investigated. And with the exception of the confession, the case against them was as strong as the case is against Hernandez. So I'm doubting that he will get retried. But, of course, there might be a public outcry, so it's always hard to decide by a DA whether to proceed or not in such a high-profile case.
This is such a high-profile case, and a lot of people will be dismayed if Hernandez just walks out of prison. That's something that the DA has to consider, too.
Yes, I agree with you completely there. There'll be public outrage if Hernandez is allowed to walk. And, you know, frankly, when you're a DA also, you're saying, my God, will I be releasing a child molester and murderer who might, in fact, hurt other people? Maybe it's worth another try to try him again. But I think really they're going to be up against a very, very difficult situation if they attempt to retry this case.
Paul, how unusual is it for a federal appellate court to reverse a state court proceeding? I mean, this was a petition for habeas relief.
It's very, very unusual for it to happen. And the reason for that is that these cases, before they get to federal court, they've usually been looked at by at least two other appellate court levels on the state court. In New York, you'd go to the appellate division and you'd go to the Court of Appeals. And by the time you bring a habeas action, which is what it's called when the feds get involved in looking at a state case for constitutional violations, you've got a record that's been carefully examined by a lot of judges who have found that the trial was fair and there were no constitutional violations. And the standard for a habeas relief is very, very high. You have to show, that there was absolutely no reason to support the state's determination not to set aside the conviction. There's a very, very high standard that's placed on the defendant to prove his innocence in a federal habeas action. So it's very rare that you win this kind of relief, especially in a high-profile case.
And this stunning appeals court reversal came just over a year after another high-profile case tried during Cyrus Vance's tenure was also reversed on appeal in another stunning decision, and that was the Harvey Weinstein case, when an appeals court found that the trial judge there shouldn't have allowed prosecutors to call witnesses who accused Weinstein of sexual abuse in incidents that were not part of the charges.
You have to say that these judges in New York have been quite brave. You have the Harvey Weinstein case, which, burned up the headlines across the country when he was convicted, and they reversed his conviction. And now, of course, you have this case. Etan Patz is the poster child of, a child being kidnapped and abused. And for the appellate court to have reversed both of these cases is a very brave move by those courts. And I think it's a tribute to them that they were carefully applying the law as it is, despite the fact that they're probably going to be criticized publicly for having done so. But I think, the evidence was clear in this case, and I also think in the Weinstein case that a reversal probably was in order. Now, maybe a retrial is in order, too, if they got the right person. But it was a brave move by these judges to reverse.
And the DA did retry Harvey Weinstein, which resulted in a mixed verdict. So we'll see if he decides to retry Hernandez. Thanks so much for joining me, Paul. That's former New York prosecutor Paul Callan. President Donald Trump has been very open about his plans to use redistricting to help Republicans retain control of the House in the 2026 midterm elections. Trump said last week that he'd spoken with Republican lawmakers in Texas and that redrawing the state's congressional map in favor of the GOP would add as many as 5 seats for the party.
It's a very simple redrawing. We pick up 5 seats. But we have a couple of other states where we'll pick up seats also.
Days later, when Governor Greg Abbott announced his agenda for the legislature's special session that started on Monday, redistricting was on the list. In the hopes of countering Trump's strategy in Texas, House Minority Leader Hakeem Jeffries is reportedly exploring the possibility of redrawing House maps in the Democratic-controlled states of California, New York, New Jersey, Minnesota, and Washington.
Donald Trump, House Republicans here in Washington, and Governor Abbott are conspiring to rig the Texas congressional map as part of an effort to disenfranchise millions of people in Texas.
Join me is elections law expert Richard Briffault, a professor at Columbia Law School. Rich, start by explaining the difference between redistricting and gerrymandering.
Sure. So redistricting and gerrymandering refer to the same thing, but gerrymandering is a kind of negative way or a critical way of describing it when it's being driven by partisan purposes. So most of, congressional delegations and state legislatures are divided up into districts. And every 10 years, they have to be redistricted based on population. As population moves around, as some areas gain and some areas lose, the Constitution requires, as interpreted by the Supreme Court, requires that districts be a relatively equal population. So usually every 10 years, usually around the year ending in 1 or year ending in 2 following the census, states redistrict. That's redistricting. Gerrymandering is a negative term we use when we say that the districting plan was driven by partisan political purposes. There are many different ways of creating a bunch of equal-sized districts, but some of them can be done in a way that favors one party over the other. The party in charge can do it in a way that breaks up areas that the other party has and splits them up into multiple districts so they can never control anything, or that's called cracking. They could also do the opposite, called packing, and put every member of the minority party in one district so that they overwhelmingly dominate one district and then have no voice anywhere else. And so gerrymandering is the phenomenon of drawing district lines in a way that produces districts of equal population but unduly favors one party over the other. Thus, a majority party gets not just a majority of the seats, but a much bigger majority than their share of the vote would require in fairness. So that's the difference.
Donald Trump has called for Republicans in several states to redraw their congressional maps to help give Republicans an even bigger advantage in the midterms. Right. As you mentioned, they usually do it every 10 years. How unusual is it to be doing it at this time?
Yeah. This kind of what might be called mid-cycle redistricting is very unusual. It's not that it's never happened before. It has sometimes happened. Although it's unusual, sometimes it happens when a new party takes over a state legislature that they hadn't had at the beginning of the decade. Here he's actually talking to states where the Republicans were already in charge of doing the districting in 2021 and saying, well, I want you to do it even more so now. And it's very rare that it's being done for so kind of blatantly, nakedly partisan purposes. There usually is some justification for it, but this time, it's being announced as purely partisan. It's purely gerrymandering, rather than any claim that there was a kind of a problem of representation with the older districts.
And the Supreme Court has said partisan gerrymandering is okay. Racial gerrymandering is not.
That's correct. I guess technically what they have said is that partisan gerrymandering is not unconstitutional. They don't endorse it, but they have said that there's nothing the federal courts can do about it. Racial gerrymandering, districting designed to help one race over another, that does raise a constitutional concern. But race and party are often very closely intertwined. And in their most recent cases, the court has basically said, if the state says it's partisan, because partisan is constitutional, we're going to defer to them. We're going to put a very heavy burden of proof on the other side challenging it to show that it's not partisan, it's racial. And here, at least what's going on in Texas, the announcement is so clearly that it's partisan. And it seems to be that, but I think it would be very hard to show that even if there's a racial component to it, it'd be very hard to show that it wasn't primarily partisan.
Republican Texas Governor Greg Abbott put redistricting on the list for this special session that started on Monday.
Right.
He said his decision was because of a letter he received from the Department of Justice earlier this month that alleges that 4 of the current districts were racial gerrymanders that violate the 14th Amendment. I mean, was that letter pretextual? Does it make any sense?
It sure seems that way. I mean, these districts were adopted 2 years ago, and they were designed to provide representation for minority groups, I think, for African Americans and Latinos. I think they were primarily Latino districts. The Constitution does not forbid that, and the Voting Rights Act actually, if it doesn't require that, at least it promotes that idea of fair representation for minorities. So no one has ever challenged those districts. And basically, the current view in the current administration seems to view that anything that even thinks about race is unconstitutional. That's not been the standard until now. The Supreme Court standard is that race can be taken into account in districting. It just can't be the overwhelming factor, the predominant factor. And I think you would have to show that these districts, of course, did help create minority representation, but that you would have to show that that was the overwhelming factor as opposed to other factors, including respect for political subdivision lines, following the cores of pre-existing districts. It does seem as though this was designed purely to give a justification for a redistricting.
But the state is...
Without anyone going to court and suing. No one has gone to court to sue to challenge those districts. If anything, there was another lawsuit that was brought from the other perspective, saying that some other districts in Texas violated the Voting Rights Act in terms of limiting minority representation, and the state had been defending them as saying that the state's districting plan was entirely constitutional. So the state has now kind of flipped its position. It's sort of, moving away from its position that everything is fine and is now considering redoing the district.
Coming up next, can Democrats really retaliate? This is Bloomberg. I've been talking to Columbia law professor Richard Briffault about Texas Republicans aiming to redraw House districts at President Trump's urging in order to help Republicans retain control of the House in the 2026 midterm elections. Rich, this is also risky for Republicans, not just legally, but electorally. Texas Democrat Gonzalez said, get ready for some pickup opportunities.
It depends on exactly what the Republicans do. But I think if what they're going to do, and as I understand it, if they take some districts where Republicans are strong and move some Republican voters into nearby districts currently held by a Democrat but have been trending Republican. And I think what happened is that in the 2024 election, a lot of districts that are held by Democrats voted for Trump. And so I think what they're thinking is that they may be able to move some Republican voters from what are clearly Republican districts into districts which have been Democratic districts but might tip Republican with a few more Republican voters. So that's the idea. Well, I've seen numbers. They think they can find as many as 5 districts that look like that. What O'Rourke is getting at is they're risking the possibility that not only won't these districts tip, but by moving Republicans out of the other districts, they risk losing those districts. A lot will turn on what the political climate is next fall in 2026. If it's a Democratic year, that is a real risk. If it's not, then the Republican strategy may work. But, at some point, there are only so many Republican and Democratic voters in a state, and the idea is to try and arrange them in such a way to maximize your party's vote. But people don't always vote exactly the same each time, and it could be that some voters switch back, and the Republicans did very well in what had been Democratic districts last time. Will they do as well next time?
3 of the districts that the Republicans want to tinker with are represented by Black and Latino lawmakers in Houston and Dallas. Reportedly, the White House is preparing a map that splits those coalitions.
Right.
So would there be a possible legal challenge there, even though difficult?
Well, one question, again, is the status of these so-called coalitions. Until recently, many courts upheld the idea that minority groups can, in effect, band together and say that we're discriminated against together by the way the district lines are drawn. There have now been some court decisions that are being challenged the idea that you could have, in effect, a lawsuit brought by a African-American Hispanic coalition, that it has to be either one or the other. So that would be a question as to whether or not, the so-called coalition is a group that has standing to bring a claim. Those coalition cases have been brought, but now I think more questions have been raised about them.
There's also a risk of retaliation. Minority Leader Hakeem Jeffries is reportedly exploring the possibility of redrawing House maps in California, New York, New Jersey, Minnesota, and Washington. And California Governor Gavin Newsom has been pretty blunt about saying we're going to redistrict here in California then. He said special sessions, special elections, ballot initiatives, new laws, it's all on the table when democracy is on the line. They have an independent commission in California, right?
I think it would be very hard to do this in California because, as is implied from Newsom's statement, they have a constitutional amendment that governs how redistricting is done. They would basically have to either supersede that amendment with a new amendment that either forever or for one time only that would change the districting process. That's really hard. I mean, I think they'd have to get something through the legislature and to the voters, and then the voters would have to approve that, and then they'd have to go and then write a new plan. And, that's a big lift as to whether or not they could get a constitutional amendment to the voters in time this year, and whether the voters would approve it. I mean, it's also pretty blatant, and although California runs Democratic, it's not clear to me that the voters would approve this. I mean, they might. And then, of course, they'd have to write a plan in a way that doesn't follow the constitutional pattern they have there. They have to come up with an entirely new system. So I guess they have to take it away from the Constitutional Commission and give it to the legislature, either always or this one time. I'm not sure what the proposal is.
And what about redistricting in other Democratic-controlled states?
Well, again, New York also has adopted a new constitutional format for redistricting, and that, I think, currently governs. I don't know about the other states. I think in the other states, it may be possible that the legislature, where they have a Democratic legislature and a Democratic governor. You mentioned Minnesota. I think the Minnesota legislature is very closely divided, and I think a key Democrat was just convicted of a crime and may have to resign, in which case it's not clear the Democrats have the Minnesota legislature. So you mentioned Washington State. That might be possible. And you're talking about picking up maybe one seat, I think, in a place like that.
I mean,
I'm guessing.
Is gerrymandering getting worse in recent years, partisan gerrymandering?
Oh, absolutely. Basically, because the computer power has gotten so much better, it has become much easier for computers to generate multiple maps, hundreds of thousands of maps that all comply with one person, one vote, and use pre-existing voting or voter registration data to maximize the number of Republican or Democratic districts. So it's no longer drawing maps, taking out big maps and drawing out, using crayon and drawing on the floor. You can generate almost an infinite number of maps by programming them to respect certain factors and not others. And that makes it incredibly easy. Then we've now the level of hyperpartisanship in the legislatures as such that they're also willing to do it. There's been something of a pushback, and I mentioned that California and New York have constitutional amendments that can try to limit gerrymandering. And a handful of other states, either by constitutional amendment or by state Supreme Court decision, there have been limits placed on gerrymandering. But where the legislatures are not limited, they have kind of infinite capacity to come up with maps that will do as much as possible to maximize the power of the party in power.
And it seems like the Democratic states are the ones with those independent commissions, et cetera, whereas the Republican states are still mostly relying on their legislatures.
Yeah. I think there is some control but I think it's relatively limited. But you're right. In Arizona, which I guess is a purple state, has a commission. But I think, we're talking about California, New York, New Jersey, and then court decisions, I think, Pennsylvania, maybe now Wisconsin. I'm not quite sure where things stand in Wisconsin.
I think this topic is pretty depressing because how do you take control away from the party in control, even if you have more people voting with the minority party, if the party in control can redistrict in these ways?
I mean, the main thing, of course, would be just a surge in voting in the opposite direction. And that sometimes happens. But you're right. If the party in power is locked in with a supermajority, even if the minority party wins the governorship, as often happens in some of these states where you have a Republican legislature and a Democratic governor, I think describes Wisconsin, for example, the governor can block some things, but the governor can't really force anything to happen. So, no, you're right. This is the problem. This is why, 60 years ago, the Supreme Court intervened with one person, one vote because the states couldn't fix it. And this is why so many people are unhappy that the Supreme Court, now it's about 6 years ago, said we're not going to interfere with partisan gerrymandering. It makes it very hard to undo. A gerrymander, if it's successful, is very hard to undo. The only possibility, we won't know about what will happen in Texas until next November, if the party in power gets too greedy and spreads itself too thin and then loses seats. That would be the comeuppance, but we don't know what's going to happen right now.
No, it all seems pretty amorphous. Thanks so much, Rich. That's Professor Richard Briffault of Columbia Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.